Good afternoon, Mr. Wooster. This is Judge Middleton, and I'm going to arraign you on a case where you failed to show up for your pre-exam conference. The file number is 26190FY. Your attorney in that case is Mr. Paul Gibson. He's here with me at the courthouse. I asked him to be here for this arraignment. Also present is Mr. Gary Gabriel from the prosecuting attorney's office. In that case, Mr. Wooster, you're charged with possession of methamphetamine and possession of appears to be cocaine.
What starts like a routine arraignment is already going sideways. Judge Jeffrey Middleton is dealing with drug charges, a missed court date, and fresh trouble after another arrest. And this is only the beginning, because today's hearing is about to shift from procedure to pure courtroom tension.
Offense was allegedly February the 5th. You posted a $15,000 surety bond when released on that bond. You were set for a pre-exam conference on February 17th, and you failed to appear for that. The court issued a bench warrant and did a notice to start the forfeiture of your bond. I understand you got arrested on the 24th and have some additional charges pending. We're going to get this case back on track. I'm going to set the pre-exam conference in conjunction with your new case, which is, Paul, are you available next? It's short notice. It's next Tuesday, March 3rd, but that's when the pre-exam is in the new case.
Yes, I am available.
All right, I'll set pre-exam conference for 3/3/26 at 8:30. Set preliminary examination if needed for 3/10/26 at 1 o'clock. Mr. Wooster, you're bound over to circuit court on an earlier methamphetamine charge from July. I just lost your case. File number.
File number is 2525820 FH, Your Honor.
Yes, thank you. Then there's this case, which is 26190. Then your new case is fleeing, eluding a police officer, assaulting and resisting a police officer, possession of methamphetamine, and a habitual offender. My inclination is to increase your bond from $15,000 to none. Just deny the bond. I also understand there may be a hold on you from Cass County. Mr. Gabriel, you got an additional input on that?
Yes, Your Honor. Obviously, I'm here because I'm concerned that methamphetamine seems to be driving his criminal behavior. Even though he can post some money to get out on bond, he turns right around and gets back into the meth. And this case, the one that occurred on February 24th, there's a lot of similarities to the one that occurred that's already up in circuit court. And that involves him deciding he's not just going to pull over and take his medicine, he's going to run. This was an extensive chase through the county by the sheriff's department, speeds hitting up to 90, 85 miles an hour. Fortunately, no one was hurt, except he crashed his car into a tree and then ran and got.
This is where the case gets serious fast. The judge is no longer looking at one mistake. He's looking at a pattern: missed court, new charges, and a dangerous fleeing case. At that point, bond stops being about money and starts being about risk.
Clearly, he's a flight risk. He can't follow the court's instructions. So I think that, and I'm not sure, but I think maybe he was arraigned yesterday on that charge.
I believe that's correct. That's why the bond in that case,
100,000,
75,000.
Okay.
I'm inclined to do no bond.
Thank you.
Mr. Gibson, that may be a moot point. It does put some pressure on the prosecutor to resolve the case, but bond can always be amended either at the pre-exam, the prelim, or the circuit court arraignment. But in light of all the circumstances, bond is denied. We didn't end up forfeiting your bond because you got picked up again, so that $15,000 you posted with a surety company will just go back to them. But for purposes of this, both of your hearings are set for pre-exam conference next Tuesday. Mr. Gibson represents you on the February 5th case. Mr. Tim George represents you on the new case. And I don't know why they keep doing that. We've been working with the Indigent Defense Commission to appoint the same lawyer on the same defendant, but they're still working on that. Anyway, you can't go anywhere, any place where, because there's a hold on you and you got a high bond in the other case. So this matter is set for next Tuesday at 8:30 a.m. for a pre-exam conference.
Thank you, Your Honor.
And Mr. Gibson, thank you for being here on short notice. All right, Mr. Wooster, see you on Tuesday. Paul, I sent you those emails about Christopher. All right, we can start early. There's no harm in that. We have two matters involving SAC Finance set for 10 a.m. this morning. First matter is SAC Finance versus Regina Mast. Ms. Mast, could you unmute your microphone? There we go. Can you hear me?
Yeah.
All right. The file number, once again, is 252423GC. SAC Finance versus Regina Mast. Mr. Andrew Rognus is here on behalf of SAC Finance. A judgment entered in this case in Noble County, Indiana, and the amount of $7,718.26 plus cost and interest, and I don't remember what the actual amount was. Ms. Mast then became subject, I think, to a garnishment after Mr. Rognus registered this foreign judgment in Michigan, and the defendant filed a motion to set aside the default. But there are a couple problems. One, more than 21 days have passed since the entry of the default. And two, the default was in Indiana.
Now the hearing pivots from criminal court to debt enforcement. This isn't Michigan retrying the old car case. It's Michigan being asked to enforce an Indiana judgment. And that legal distinction is exactly why the judge keeps focusing on authority, not emotion.
And what is going on here is just a ministerial registering of this judgment from another state so they can try to collect it here. Ms. Mast, you filed a motion. I think we waived the fees. You attached a bunch of stuff about the car, and this is the same thing we always get, the car conked out. This happened 8 years ago, and the judgment entered in Indiana. And Mr. Rognus then registered it here. Mr. Rognus, you filed a brief, which I appreciate. You wish to speak to this further?
Yes, Your Honor. Originally, the promissory note or the contract was executed by Ms. Mast when she lived in Indiana. When they did file suit on this, they had to utilize what in Indiana they call an alias summons, and here in Michigan we call alternate service. And they perfected service in Indiana pursuant to trial rule 4.1. So I don't necessarily know that there is any basis to make a collateral attack on that judgment. And as I did indicate in our brief, I guess it's not ideal, but she's only accumulating interest at the Indiana statutory rate of 8%. instead of the Michigan statutory rate at 13%. Certainly, if she wants to talk about setting up a wage assignment or something like that, our standard operating procedure is once they're paid off, we'll do a step to set aside the judgment, dismiss the case, help them out substantially with their credit history as well.
Ms. Bass, what triggered this? This judgment entered way back in 2017. And what normally happens is things just lay dormant until they actually start to try to collect. So what caused you to file this motion to set it aside?
I was never aware of it. They apparently served me the papers at an address I hadn't lived at for years. So I didn't even know about it until it was too late.
And they sent us a paper last year saying they're gonna put a lien on our property, and that's when we found out about it. Tell them that.
Yeah, we got a paper in the mail, I think last year, saying that they were going to try to take a lien out on property that I don't even own. And that was how we found out.
I have no idea, Your Honor. My presumption is that came from the Indiana attorney. But if you were aware at that point in time, you probably should have undertaken something rather than to waive that and be a stop from proceeding further.
Yeah, you have 21. First of all, Indiana says you were served by Deputy Sammy Bremer, Bremer, on June 22nd, 2017. And he filed a document.
Okay, we didn't live there. We gave you a lease for a land contract house we purchased in 2017 before that date. And before that, we lived for a year in 2016 at 185 Station Street. This is a motion to set aside because we were not properly served, whether it was 8 years
He
ago.
swore that he served you personally, handed
No.
it to you.
No, I don't think it says serve personally, Your Honor. I think there's
No,
Oh, by their rule. Oh, yeah. Delivering copy of someone's dwelling house.
that's what this is about. We were never properly served. Therefore, it has to be set aside because we had no clue about it. We could never go to the
Just a minute.
trial.
Who's speaking?
I'm a witness to the matter that she
All right,
lived
well,
with
you're
me.
not
Right here, the tone changes completely. The moment another person starts speaking on Regina Mast's behalf, the judge shuts it down. In court, knowing the story is not the same as having the legal right to argue it.
a lawyer. You're not a lawyer, and you
Okay.
can't represent Miss Mast. So if you just be quiet.
Okay.
Your ship sailed. You got served by Indiana Service in 2017. Whatever that service was good enough for Indiana. So the judgment is Indiana. We then registered the judgment here. And all this business about the car conked out and all that stuff
We're not properly served. Tell them
is
that.
not necessarily a defense. This is a loan to purchase
That's
the
not a
car.
defense.
In 2017, I hadn't lived in Michigan for years. So I don't understand how that's okay for them to serve papers to a home I didn't live in.
That's the bottom line.
Well, it was good enough for Indiana to enter the judgment. So if you want to move to set the judgment aside, you have to do it in Indiana. I don't have the authority to set aside the Indiana judgment. Now let's assume they set it aside. In order to set aside a default judgment, generally, you have to establish a meritorious defense and a reason for not responding. Your reason for not responding is you contend that you were not served. I don't know what your meritorious defense is. We may set that aside and say, yeah, you do owe all this money. You borrowed this money, the car was repossessed, and this is what's left over after the sale. So,
I mean, worst case scenario, Your Honor, we
say that again.
Michigan on the promissory note, and then she's at a higher interest rate.
Well, that's not to her advantage, but it's an Indiana judgment. And I do not have the authority to set aside an Indiana judgment.
It's a Michigan claim, though. You're trying to take money out of Michigan. You're a Michigan lawyer. You're a Michigan judge, sir. We had no clue
Yes.
about this.
You're not a lawyer, so shut up. You don't have the right to speak on her behalf.
I'm a witness. I'm a
Well,
character witness.
Witnesses don't just come in and represent the person that's the named party. So
The bottom line.
when you get a law degree, you can represent her and you can tell me what the law is, not something you read on the internet. This is an Indiana judgment that entered in 2017. Nothing was ever done. You never paid anything. You knew you had a judgment. At some point, you knew a year ago they had a judgment, and you never started to pay anything until they started to collect. So, Mr. Rognus, are you willing to speak with them regarding their options?
I will, Your Honor, if Ms. Mast would get in touch with me later on, or if you want to put her into a breakout room, if she's got the time. We've got another.
Let's do a breakout room. Sir, you can speak outside the court. So with Mr. Rognus, you can make your point, but.
It's fine. We never knew about it. We're getting screwed. Now you're screwing us too. It's fine.
Okay.
We prove without a matter of a doubt that we did not live in Indiana. That's fair grounds for you to set this aside. We did not live in Indiana.
Stop. If you want to set it aside, you have to do it in Indiana.
This is a Michigan judgment, sir.
Yes, I understand.
Ms. Mast, if you want to get in touch with me, please do so at some point. It's obvious right now that maybe nothing's going to get it. Okay.
Do I have to go through Indiana court systems to do that? Is that it's been
Well,
past
let's
21
talk about
days 'cause
this.
I did it through
Let's
Michigan.
assume you set it aside. What's your defense? They set aside the judgment and then they just start over again.
It's your limitations.
What's your defense? You're supposed to file what's called a meritorious affidavit of defense that says, I don't owe this money because I was the wrong person. I already paid it off.
At the wrong place. They went and up through the back door, basically served it without actually serving me, just so that it would do that, and they would automatically get it because I wasn't served.
That service was adequate for Indiana.
How? I didn't live there. How is that adequate for any?
This is the core legal issue. The defendant says she was never properly served, but the judge keeps returning to 2 points. Indiana entered the judgment, and Indiana is where that challenge likely has to start. And even then, the debt itself may still survive.
Those are the Indiana rules. You took out a loan with those people. That's the address you gave them. They sent it by first class mail. They posted it there. I can't speak to the Indiana rules, but Mr. Rognus cites it in his brief.
When they came and repossessed the car, I told them to come get it at my address where I lived in Michigan. They picked up the car in Michigan, so they knew I didn't live in Indiana. And yet they still served me in Indiana.
The judge thinks that you were served by a chief of police there when it never happened.
I'm not saying that you were served. Whatever service you got was adequate under Indiana law. And even if I did set it aside, they're going to say, you still owe the money because we had to repossess this car and sell it. And this is the shortfall.
The statute of limitations is 4 years in Indiana. So they're past their statute of limitations. If it's set aside, they can't bring it back up because it's past the statute of limitations.
Well, I don't know what the statute of limitations is in Indiana,
4 years. 4 years. It's been almost 10.
Well, you can take it up with them.
Ridiculous.
Motion to set it. Now, Ms. Mast, let me repeat. You got a couple options. You can call Mr. Rognus at any time and he'll speak. You can go to Noble County and try to set the original judgment aside. This is an Indiana judgment that was registered in Michigan. It complied with the Indiana rules and we registered it here. So I'm not saying that it's fair. Thought I had an order in here. I do. Anyway, the order to set aside the default is denied. First of all, once you get notice of it in Michigan, you have 21 days to move to set the default aside, which
I
you
did.
didn't do.
You were on vacation, sir. We did that. We did
All
that.
right, you shut up. You
Well,
just
stop
shut
fucking
up.
lying,
You don't
Bill.
have the
Stop
authority to
lying.
speak.
Stop lying,
So-
Judge Middleton.
The motion to set aside the
Tell 'em.
default was filed
On December 18th.
Soon
December
as we got it in the
18th.
mail. Soon as we got it in the mail, we filed a motion. You were on vacation, sir.
All right, let's take a look.
Yeah.
Again,
Take a
shut
look.
up. You don't have the right to say anything. You just be
Don't tell me to
quiet.
shut up, sir.
I'm gonna mute her microphone. Yes, he doesn't have the authority to represent her. He's a witness.
Now things get even more frustrating. The judge acknowledges the motion was filed earlier than he first thought, but the ruling still doesn't change. Why? Because in his view, the real barrier isn't timing, it's jurisdiction.
Somehow this got lost by the clerk. They did file it on December 18th. And I didn't see it until January 21st. And they set a hearing date. And they entered a garnishment before we had the hearing on the motion to set aside the default. And then I think maybe it was set the day the courthouse flooded. So we moved the hearing up. And we reset it at an unusual time, which was this morning. So the time that you filed the motion to set aside the default was not from the time that you learned you had a judgment. It was for the time they started to garnish your wages. Those are two different things. So the motion to set aside the default judgment is denied. It's an Indiana judgment, and the judgment was entered in Noble County, Indiana, which apparently complied with the Indiana rules. I don't believe I have the authority to set aside an Indiana judgment, whether you were properly served or not. If you were properly served, then the judgment stands. They filed something called, and Mr. Brogdon provided you a copy of it, an alias summons, which is an Indiana statute that allows them to do what we call alternative service. And secondly, once you found out about the Michigan judgment, he didn't file the motion within 21 days to set it aside. He filed it within 21 days of being informed of the garnishment. So the motion to set aside the default is denied. You can talk to Mr. Rognes at any time. You can call his office, or you can contact the officials in Noble County. But you don't want this garnishment. It's going to take a great big chunk of your money. They can agree to something like an installment payment order or something else. I do have the authority to change the payment. If you filed a motion for installment payments, I could set aside the garnishment on that basis, but I can't set it aside because it's from Indiana. Let me repeat. You can contact Mr. Rognes by phone at any time or stop in at his office. He will discuss this with you. He has the authority to set aside this garnishment and enter into some sort of repayment agreement. you can ask me to set aside the garnishment with a request for installment payments. Or you can go to Noble County, Indiana and try to set aside the original judgment from 2017. That is not going to be easy to do. This alien summons that they have in Indiana was apparently sufficient for the Noble County Court to enter a default. All right. I guess you don't have to like it. I probably wouldn't like it either. The other issue is whether you have a meritorious defense, even if it is set aside. Your argument that you don't owe the money, it's going to have to be prevailed in Indiana. So, all right. I'm sorry you don't like it, and I wouldn't like it either, but your motion set aside the default is denied, and I will do the order. All right. And again, you can contact Mr. Rognus at any time. It isn't respectful to tell people to shut up, so I kind of lost it, but
I've dealt with him before. I don't know.
I didn't even get his name.
Yeah, he was the dog charge case from Constantine when I was still working with Dave in the prosecutor's office.
Anyway, she's in a tough spot, but the fundamental thing, they probably don't have a meritorious defense.
Yeah.
So even if it is set aside in the other state, she's going to have a hard time. So she's just going to have to look at a way to pay this.
And I'll talk with her about setting something up.
All right.
Just thought maybe call me on a different date when he's not all.
Well, you were willing to go into a breakout room, but you could see that it wasn't going to go very well.
Okay.
Let's do our other case. The other case is SAC Finance versus Alexis Smoker. This is the case where a garnishment issued before you had a judgment.
No, I don't think that's what happened, Your Honor. I think.
Well, let me call the case.
Okay.
It's 251223 GC, SAC Finance versus Matthew and Alexis Smoker. Attorney Andrew Rognus is here for the plaintiff. The Smokers are not here. Again, this was a garnishment, and there was some urgency to it. What's the status here, Mr. Rognus?
Your Honor, the judgment in this case actually entered back on September 16, 2025. Somehow we made a mistake and shipped a garnishment to the employer that didn't get file stamped by the clerk. When we found out, when Kim called us, we verbally contacted the employer and got them to release the garnishment, but they wanted it followed up with a file stamp copy of the release. I can get one over to the court right away, but we've received no money on the garnishment after I contacted them on the phone, and I don't believe Mr. Smoker's had anything taken out of his wages, because I think we caught Speedway payroll before the next check went out.
So you've released the garnishment?
I sent them an email and fax to them that I verbally released the garnishment, sent a blank release form, but it's got to have the clerk's signature on it.
Here or there?
Anywhere. Yeah.
All right, where is that form?
I can email
right
it.
Here.
Is that a release form?
Yes.
Okay.
Garnishment release.
Okay, so
All
you've already got it.
All right, I can execute that. Yes.
I think there is a release in there, Judge, but me and Kim didn't know what to do.
I'm gonna sign it.
Okay.
And then when I get that, I will shoot it along to the people at Speedway. But then eventually we'll have another one, I think, in the pipeline to do it.
Yes.
Yeah, I don't know how that happened. We're generally pretty careful about the stuff that goes out of here, but that one's on me. I mean, my name's on the letterhead, so I gotta take the spanking.
Well, you haven't collected anything, so I guess it isn't fatal. I've signed the garnishment release at 7-Eleven Speedway regarding Matthew Ryan Smoker. And
By the end, the court sends one clear message: authority matters. One defendant loses bond, another loses a motion to undo an out-of-state judgment, and a third garnishment issue gets corrected. If this case shocked you too, like, share, comment, and subscribe for more courtroom analysis.
all right, I think that resolves both of our matters. I feel for Miss Mast, but she's got to deal with that.
Yeah, if you could have
All right.
Works
Thank
email that release to me, I will send that to Speedway yet today.
All right, and I do have the order regarding set aside default. The court was without jurisdiction after hearing.
On this one?
No, on Mast.
Okay, yeah.
Tuesday was an odd time to set these, but both involved garnishments and were important to each defendant. We didn't do very well with Miss Mast, but the smokers, the garnishments set aside. All right, thank you.